do so with the intent to impair the object's integrity or availability for use in an official proceeding. The next subsection extends that prohibition to anyone who otherwise obstructs, influences, or impedes any official proceeding or attempts to do so. Petitioner Joseph Fischer was charged with violating subsection 1512c2 for his conduct on January 6, 2021. On that day, Congress convened with a joint session to certify the votes in the 2020 presidential election. While they did so, a crowd of supporters of then-President Donald Trump gathered outside the Capitol, and some eventually forced their way into the building, breaking windows and assaulting police. This breach of the Capitol delayed the certification of the vote. The criminal complaint alleges that Fischer was among those who invaded the building. Fischer was charged with various crimes for his actions on January 6, including obstructing an official proceeding in violation of subsection 1512c2. He moved to dismiss that charge, arguing that the provision criminalizes only attempts to impair the availability or integrity of evidence. The district court granted his motion in relevant part. A divided panel of the D.C. Circuit reversed and remanded for further proceedings. Held. To prove a violation of subsection 1512c2, the government must establish that the defendant impaired the availability or integrity for use in an official proceeding of records, documents, objects, or other things used in an official proceeding, or attempted to do so. To determine the scope of the residual otherwise clause in subsection 1512c2, the court must decide how it is linked to its surrounding words, and give effect, if possible, to every clause and words of the statute. The court considers both the specific context in which C2 appears and the broader context of the statute as a whole. Section 1512c1 describes particular types of criminal conduct in specific terms. The purpose of C2 is, as the parties agree, to cover some set of matters not specifically contemplated by C1. Perhaps Congress sought to criminalize all obstructive acts in 1512c2, and having named a few examples in C1, devised C2 to prohibit the rest. But C2 could have a narrower scope if Congress designed it to fill inadvertent gaps in the focused language of C1. One way to discern the reach of an otherwise clause is to look for guidance from whatever examples come before it. Two general principles are relevant. First, the canon of non scitur associis teaches that a word is given more precise content by the neighboring words with which it is associated. And under the related canon of ejusdem generis, a general or collective term at the end of a list of specific items is typically controlled and defined by reference to those specific items that precede it. These approaches to statutory interpretation track the common sense intuition that Congress would not ordinarily introduce a general term that renders meaningless the specific text that accompanies it. Under these principles, the otherwise provision of subsection 1512c2 is limited by the list of specific criminal violations that precede it in C1. If, as the government asserts, C2 covers all forms of obstructive conduct beyond subsection 1512c1's focus on evidence impairment, Congress would have had little reason to provide any specific examples at all, and the sweep of subsection C2 would swallow C1, leaving that narrower provision with no work to do. Tethering subsection C2 to the context of C1 recognizes the distinct purpose of each provision. Subsection C1 refers to a defined set of offense conduct, four types of actions that, by their nature, impair the integrity or availability of records, documents, or objects for use in an official proceeding. Reading the otherwise clause as having been given more precise content by C1, subsection C2 makes it a crime to impair the availability or integrity of records, documents, or objects used in an official proceeding in ways other than those specified in C1. For example, it is possible to violate C2 by creating false evidence rather than altering incriminating evidence. Subsection C2 also ensures that liability is still imposed for impairing the availability or integrity of other things used in an official proceeding beyond the records, documents, or other objects enumerated in C1, such as witness testimony or intangible information. it makes sense to read C2 as limited by C1 in light of the history of the provision. The Enron accounting scandal exposed a loophole in subsection 1512. At that time, the statute imposed liability on anyone who, among other things, corruptly persuaded another person to shred documents. But it curiously failed to impose liability on a person who destroyed records himself. The parties agree that Congress enacted 1512C as part of the broader Sarbanes Oxley Act to plug this loophole. It would be peculiar to conclude that in closing the Enron gap, Congress created a catch-all provision that reaches beyond the scenarios that prompted the legislation. The broader context of subsection 1512 in the criminal code confirms that C2 is limited by the scope of C1. Federal obstruction law consists of numerous provisions that target specific criminal acts and settings, much of which would be unnecessary if C2 criminalized essentially all obstructive conduct. Given the court's obligation to give meaning where possible to each word and provision in the code, the court's narrow interpretation of subsection C2 is the superior one. An unbounded interpretation of subsection C2 would also render superfluous the careful delineation of different types of obstructive conduct in 1512 itself. That section provides a reticulated list of nearly 24 means of committing obstruction with penalties ranging from 3 years to life in prison or even death. The government's reading would lump together under C2 disparate types of conduct for which Congress had assigned proportionate sentences. The government's theory would also criminalize a broad swath of prosaic conduct, exposing activists and lobbyists to decades in prison. Our usual approach in obstruction cases has been to resist reading particular sub-provisions to create a cover-all statute. Nothing in the text or statutory history gives the court a reason to depart from that practice today, and the government's interpretation would give prosecutors broad discretion to seek a 20-year maximum sentence for acts Congress saw fit to punish with far shorter sentences. By reading C2 in light of C1, the court affords proper respect to the prerogatives of Congress in carrying out the quintessentially legislative act of defining crimes and setting the penalties for them. Vacated and remanded. Chief Justice Roberts delivered the opinion of the court in which Thomas, Alito, Gorsuch, Kavanaugh, and Jackson joined. Jackson filed a concurring opinion, and Barrett filed a dissenting opinion in which Sotomayor and Kagan joined. It's a bit unusual. Chief Justice Roberts delivered the opinion of the court. The Sarbanes-Oxley Act of 2002 imposes criminal liability on anyone who corruptly alters, destroys, mutilates, or conceals a record, document, or other object, or attempts to do so with the intent to impair the object's integrity or availability for use in an official proceeding. The next subsection extends that prohibition to anyone who otherwise obstructs, influences, or impedes any official proceeding or attempts to do so. We consider whether this otherwise clause should be read in light of the limited reach of the specific provision that precedes it. This case concerns the prosecution of petitioner Joseph Fischer for his conduct on January 6, 2021. That day, both houses of Congress convened in a joint session to certify the votes in the 2020 presidential election. While they did so, a crowd of supporters of then-President Donald Trump gathered outside the Capitol as set forth in the criminal complaint against Fischer. Some of the crowd eventually forced entry into the building, breaking windows and assaulting members of the U.S. Capitol Police. This breach of the Capitol caused members of Congress to evacuate the chambers and delayed the certification process. The complaint alleges that Fischer was one of those who invaded the building. According to the complaint, about an hour after the House's recessed, Fischer trespassed into the Capitol and was involved in a physical confrontation with law enforcement. Fischer claimed in Facebook posts that he pushed police back about 25 feet and that he was inside the Capitol talking to police. Body camera footage shows Fischer near a scrum between the crowd and police who were trying to eject trespassers from the building. A grand jury returned a 7-count superseding indictment against Fischer. 6 of those counts allege that Fischer forcibly assaulted a federal officer, entered and remained in a restricted building, and engaged in disorderly and disruptive conduct in the Capitol, among other crimes. Those 6 counts carry maximum penalties ranging from 6 months to 8 years imprisonment. In count 3, the only count now before us, the government charged Fischer with violating 18 U.S.C. subsection 1512c2. Fischer moved to dismiss that count, arguing that the provision criminalizes only attempts to impair the availability or integrity of evidence. The district court granted his motion in relevant part. It concluded that the scope of section 1512c2 is limited by subsection c1, and therefore requires the defendant to have taken some action with respect to a document, record, or other object. A divided panel of the D.C. Circuit reversed and remanded for further proceedings. Judge Pan, writing for the court, held that the word otherwise in Section 1512c2 means that the provision unambiguously covers all forms of corrupt obstruction of an official proceeding other than the conduct that is already covered by 1512c1. Judge Walker concurred in part and concurred in the judgment because he read the mens rea element of the statute corruptly and as requiring a defendant to act with an intent to procure an unlawful benefit. Judge Katsas dissented. In his view, the language in subsection C1 narrows the language that comes after the word otherwise in subsection C2. He therefore construed section 1512C2 as applied only to acts that, like the ones specified in C1, affect the integrity or availability of evidence at an official proceeding. We granted certiorari. The controversy before us is about the scope of the residual otherwise clause in section 1512c2. On the one hand, Fischer contends that c2 applies only to acts that affect the integrity or availability of evidence. On the other, the government argues that c2 captures all forms of obstructive conduct beyond section 1512c1's focus on an evidence impairment. Resolving such a dispute requires us to determine how the residual clause is linked to its surrounding words. In doing so, we must give effect, if possible, to every clause and word of the statute. To that end, we consider both the specific context in which C2 appears and the broader context of the statute as a whole. Section 1512 provides, whoever corruptly alters, destroys, mutilates, or conceals a record, document, or other object, or attempts to do so with the intent to impair the object's integrity or availability for use in an official proceeding, or otherwise obstructs, influences, or impedes any official proceeding, or attempts to do so, shall be fined or imprisoned not more than 20 years, or both. Subsection C1 describes particular types of criminal conduct in specific terms. To ensure the statute would not be read as excluding substantially similar activity not mentioned, C2 says it is also illegal to engage in some broader range of unenumerated conduct. The purpose of the otherwise clause is therefore, as the parties agree, to cover some set of matters not specifically contemplated by C1. The problem is defining what exactly Congress left for C2. Perhaps Congress sought to criminalize all obstructive acts in Section 1512C, and having named a few examples in C1, devised C2 to prohibit the rest in one go. The point of C1 would be to illustrate just one type of conduct among many C2 prohibits. It would be subsidiary to the overarching prohibition in C2. But C2 could well have a narrower scope if Congress designed it with the focused language of C1 in mind. Subsection C1 would then prohibit particular types of obstructive conduct, and C2 would fill any inadvertent gaps that might exist. One way to discern the reach of an otherwise clause is to look for guidance from whatever examples come before it. Two general principles are relevant. First, the canon of non-setur a socis teaches that a word is given more precise context by the neighboring words with which it is associated. That avoids ascribing to one word a meaning so broad that it is inconsistent with the company it keeps. And under the related canon of ejusdem generis, a general or collective term at the end of a list of specified terms is typically controlled and defined by reference to the specific classes that precede it. These approaches to statutory interpretation track the common sense intuition that Congress would not ordinarily introduce a general term that renders meaningless the specific context or the specific text that accompanies it. To see why, consider a straightforward example. A zoo might post a sign that reads, "Do not pet, feed, yell, or throw objects at the animals, or otherwise disturb them." If a visitor eats lunch in front of a hungry gorilla or talks to a friend near its enclosure, has he obeyed the regulation? Surely yes. Although the smell of human food or the sound of voices might well disturb gorillas, the specific examples of impermissible conduct all involve direct interaction and harassment of the zoo animals. Merely eating or talking is so unlike the examples that the zoo provided that it would be implausible to assume those activities were prohibited, even if literally covered by the language. The idea is simply that a general phrase can be given a more focused meaning by the terms linked to it. That principle ensures, regardless of how complicated a sentence might appear, that none of its specific parts are made redundant by a clause literally broad enough to include them. For instance, a football league might adopt a rule that players must not grab, twist, or pull a face mask, helmet, or other equipment with the intent to injure a player or otherwise attack, assault, or harm any player. If a linebacker shouts insults at the quarterback and hurts his feelings, has the linebacker nonetheless followed the rule? Of course he has. The examples of prohibited actions all concern dangerous physical conduct that might inflict bodily harm. Trash talk is simply not of that kind. Similarly, improbable consequences can result from untethering an otherwise provision from the rest of a criminal statute. The question there was whether driving under. Take Begay versus United States. The question there was whether driving under the influence qualified as a violent felony under the Armed Career Criminal Act, ACCA. A violent felony was defined in relevant part by ACCA as a crime punishable by more than a year's imprisonment that is burglary, arson, or extortion, involves the use of explosives, or otherwise involves conduct that presents a serious potential risk of physical injury to another. We recognize that, depending on the context, the word otherwise can, though not must, refer to a crime that is similar to the listed examples in some respects, but different in others. And we held that while driving under the influence certainly may present a serious risk of physical injury, such an offense was so dissimilar from the previously enumerated examples that it could not be classified as a violent felony under the statute. The list of crimes that preceded the residual clause, burglary, arson, extortion, and the use of explosives, focused on purposeful, violent, and aggressive conduct. And if that focus did not extend to the residual clause, ACCA's 15-year mandatory minimum sentence would apply to a host of offenses not typically committed by those whom one normally labels armed career criminals, and that were far removed from the deliberate kind of behavior associated with violent criminal use of firearms. The otherwise provision of Section 1512c2 is similarly limited by the preceding list of criminal violations. The offenses enumerated in subsection C1 cover someone who alters, destroys, mutilates, or conceals a record, document, or other object with the intent to impair the object's integrity or availability for use in an official proceeding. Complex as subsection C1 may look, it simply consists of many specific examples of prohibited actions undertaken with the intent to impair an object's integrity or availability for use in an official proceeding, altering a record, altering a document, concealing a record, concealing a document, and so on. That list is followed immediately by a residual clause in C2. Guided by the basic logic that Congress would not go to the trouble of spelling out the list in C1 if a neighboring term swallowed it up, the most sensible inference is that the scope of C2 is defined by reference to C1. If, as the government asserts, C2 covers all forms of obstructive conduct beyond Section 1512's focus on evidence impairment, there would have been scant reason for Congress to provide any specific examples at all. The sweep of subsection C2 would consume C1, leaving that narrow provision with no work to do. Indeed, subsection C1 would be an elaborate pump fake, a list of 4 types of highly particularized conduct performed with respect to a record, document, or object, and with the intent to impair the object's integrity or availability for use in an official proceeding, followed in the very next subsection, in the same sentence no less, by a superseding prohibition on all means of obstructing, influencing, or impeding any official proceeding. Construing Section 1512 in such a way gets the familiar analysis we apply to these types of statutes exactly backwards, eliminating specific terms because of broad language that follows them, rather than limiting the broad language in light of narrower terms that precede it. Tethering subsection C2 to the context of C1 recognizes the distinct purpose of each provision. As we have explained, subsection C1 refers to a defined set of offense conduct, 4 types of actions that, by their nature, impair the integrity or availability of records, documents, or objects for use in an official proceeding. When the phrase otherwise obstructs, influences, or impedes any official proceeding is read as having been given more precise content by that narrower list of conduct, subsection C2 makes it a crime to impair the availability or integrity of records, documents, or objects used in an official proceeding in ways other than those specified in C1. For example, it is possible to violate C2 by creating false evidence, rather than altering incriminating evidence. Subsection C2 also ensures that liability is still imposed for impairing the availability or integrity of other things, used in an official proceeding beyond the records, documents, or other objects, enumerated in C1, such as witness testimony or intangible information. The dissent supposes that because the word otherwise in C2 can mean in a different manner, by other means, or in other respects, C1 and C2 are distinct and independent prohibitions. But the word otherwise is not by itself sufficient to demonstrate that the examples do not limit the scope of the clause. Otherwise can link otherwise can link a set of examples to a general phrase and give it more definite meaning, even in statutory sentences that rival the complexity of Section 1512C. It makes sense to read subsection C2 as limited by C1 in light of the history of the provision. Prior to the Sarbanes Oxley Act, Section 1512 imposed criminal liability on anyone who knowingly uses intimidation or physical force, threatens or corruptly persuades another person to, among other things, shred documents. But the Enron accounting scandal revealed a loophole. Although Enron's outside auditor, Arthur Anderson, had systematically destroyed potentially incriminating documents, the statute curiously failed to impose liability on a person who destroyed the records himself. As a result, prosecutors had to prove that higher-ups at Enron and Arthur Anderson persuaded someone else to shred documents rather than the more obvious theory that someone who shreds documents is liable for doing so. The parties agreed that to plug this loophole, Congress enacted Section 1512C, the provision at issue here, as part of the broader Sarbanes-Oxley Act. It would be peculiar to conclude that in closing the Enron gap, Congress actually hid away in the second part of the third subsection of Section 1512 a catch-all provision that reaches far beyond the document shredding in similar scenarios that prompted the legislation in the first place. The better conclusion is that subsection C2 was designed by Congress to capture other forms of evidence and other means of impairing its integrity or availability beyond those Congress specified in C1. The broader context of Section 1512 in the Criminal Code confirms that C2 is limited by the scope of C1. Federal obstruction law consists of numerous provisions that target specific criminal acts and settings. Much of that particularized legislation would be unnecessary if C2 criminalized essentially all obstructive conduct, as the government contends. Section 1503A, for example, makes it a crime to corruptly or by threats of force or by any threatening communication endeavor to influence, intimidate, or impede any juror or court officer. Section 1504 covers attempting to influence jurors through written communications. Section 1505 covers anyone who corruptly obstructs congressional inquiries or investigations. Section 1507 covers picketing or parading in certain locations with the intent of interfering with, obstructing, or impeding the administration of justice. Section 1509 covers the obstruction of the exercise of rights or performance of duties under court orders. Section 1510A covers obstruction of federal criminal investigations through bribery. Section 1511A covers certain obstruction of state or local law enforcement with the intent to facilitate illegal gambling, and Sections 1516, 1517, and 1518 address obstructive acts in specific contexts, including federal audits, examinations of financial institutions, and inquiries into healthcare-related offenses. If the government were correct, then the otherwise obstructs, influences, or impedes any official proceeding provision, which is buried in subsection C2 of Section 1512, would largely obviate the need for that broad array of other obstruction statutes. In light of our obligation to give meaning where possible to each word and provision in the code, our narrower interpretation of subsection C2 is the superior one. An unbounded interpretation of subsection C2 would also render superfluous the careful delineation of different types of obstructive conduct in Section 1512 itself. That section provides a reticulated list of nearly 24 means of committing obstruction, with varying degrees of culpability and penalties ranging from 3 years to life in prison or even death. Section 1512A2B4, for example, authorizes up to 30 years imprisonment for someone who uses or attempts to use physical force against another person with the intent of causing him to be absent from an official proceeding. Section 1512D1, by contrast, authorizes only 3 years imprisonment for someone who harasses another person and thereby dissuades him from attending an official proceeding. Reading C2 to cover all forms of obstructive conduct would override Congress's careful delineation of which penalties were appropriate for which offenses. Most instances of those prohibited acts would instead fall under subsection C2's sweeping reach, which provides a 20-year maximum term of imprisonment. Such a reading of subsection C2 would lump together disparate types of conduct for which Congress had assigned proportionate penalties in A2 and D1. The government's response to this surplusage problem are not convincing. It first argues that because other provisions in Section 1512 would allow conviction in some circumstances on a lesser mens rea than corruptly, they have a broader compass than C2. For instance, the government contends that subsection B can be violated by knowing use of intimidation or threats or misleading conduct, but the government concedes that Congress did not define corruptly for purposes of Section 1512. And while the government suggests that corruptly is normally associated with wrongful, immoral, depraved, or evil conduct, it never persuasively explains how knowingly using intimidation or threats against someone is not wrongful. The same is true for most other subparts of Section 1512, that the government identifies as having a lesser mens rea than C2. None of those other provisions has a mens rea the government may more readily establish than the corruptly mens rea of subsection C2. The government also contends that its interpretation creates no surplusage because Section 1512's other provisions sweep more broadly than an official proceeding. To be sure, subsections A2C, B3, and D2 criminalize various means of preventing someone from giving a judge or law enforcement officer information related to the commission or possible commission of a federal offense or a violation of conditions of supervised release. And subsections D3 and 4 make it a crime to harass someone and thereby dissuade them from arresting or prosecuting a person alleged to have committed a federal offense. None of these crimes require an official proceeding, but not much, if any, conduct covered by those provisions would escape the government's expansive interpretation of subsection C2. For a person to have violated C2, an official proceeding need not be pending or about to be instituted. And because interference with an arrest or with communications to authorities about federal offenses could very well obstruct the initiation of future official proceedings, the government's reading of C2 would still often consume violations of A2C, B3, and D2, 3, and 4. The dissent tries to solve this surplusage problem by arguing that conduct only violates C2 if it has a relationship in time, causation, or logic with an official proceeding. Assuming there is such a requirement, it would simply mean that the defendant's actions must have the natural and probable effect of interfering with the proceeding. Such a bar on prosecutions based on speculative theories of obstruction would hardly cabin the reach of C2. The dissent points out that our reading creates some surplusages too. In a wide-ranging scheme like Chapter 73, it is true that some provisions will inevitably cover some of the same conduct, but surplusage is nonetheless disfavored, and our construction that creates substantially less of it is better than a construction that creates substantially more. On the government's theory, Section 1512C consists of a granular subsection C1, focused on obstructive acts that impair evidence, and an overarching subsection C2 that reaches all other obstruction. Even setting surplusage aside, that novel interpretation would criminalize a broad swath of prosaic conduct, exposing activists and lobbyists alike to decades in prison. As the Solicitor General acknowledged at oral argument, under the government's interpretation, a peaceful protester could conceivably be charged under 1512C2 and face a 20-year sentence. And the government would likewise have no apparent obstacle to prosecuting under C2 any lobbying activity that influences an official proceeding and is undertaken corruptly. Those peculiar results underscore the implausibility of the government's interpretation. Our usual approach in obstruction cases has been to resist reading particular subprovisions to create a coverall statute, as the government would have us do here. And there is no reason to depart from that practice today. Nothing in the text or statutory history suggests that subsection C2 is designed to impose up to 20 years imprisonment on essentially all defendants who commit obstruction of justice in any way and who might be subject to lesser penalties under more specific obstruction statutes. If Congress had wanted to authorize such penalties for any conduct that delays or influences a proceeding in any way, it would have done so. Instead, Section 1512 mentions record, document, or other object 26 times. Rather than transforming this evidence-focused statute into a one-size-fits-all solution to obstruction of justice, we cabin our reading of subsection C2 in light of the context of subsection C1. Doing so affords proper respect to the prerogatives of Congress in carrying out the quintessentially legislative act of defining crimes and setting the penalties for them. We have long recognized that the power of punishment is vested in the legislative, not in the judicial department, and we have, as a result, traditionally exercised restraint in assessing the reach of a federal criminal statute. The government's reading of Section 1512 would intrude on that deliberate arrangement of constitutional authority over federal crimes, giving prosecutors broad discretion to seek a 20-year maximum sentence for acts Congress saw fit to punish, only with far shorter terms of imprisonment. For example, 3 years for harassment under Section 1512, subsection 1512 D1, or 10 years for threatening a juror under subsection 1503. For all these reasons, subsection C2's surrounding words suggest that we should not give this otherwise provision the broadest possible meaning. Although the government's all-encompassing interpretation may be literally permissible, it defies the most plausible understanding of why C1 and C2 are conjoined, and it renders an unnerving amount of statutory text mere surplusage. Given that subsection C2 was enacted to address the Enron disaster, not some further flung set of dangers, it is unlikely that Congress responded with such an unfocused and grossly incommensurate patch. We therefore decline to adopt the government's interpretation, which is inconsistent with the context from which the statute arose. To prove a violation of Section 1512c2, the government must establish that the defendant impaired the availability or integrity for use in an official proceeding of records, documents, objects, or, as we earlier explained, other things used in the proceeding, or attempted to do so. The judgment of the D.C. Circuit is therefore vacated, and the case is remanded for further proceedings consistent with this opinion. On remand, the D.C. Circuit may assess the sufficiency of Count 3 of Fischer's indictment in light of our interpretation of Section 1512c2. It is so ordered. Justice Jackson concurring. On January 6, 2021, an angry mob stormed the United States Capitol seeking to prevent Congress from fulfilling its constitutional duty to certify the electoral votes in the 2020 presidential election. The peaceful transfer of power is a fundamental democratic norm, and those who attempt to disrupt it in this way inflicted a deep wound on this nation. But today's case is not about the immorality of those acts. Instead, the question before this court is far narrower. What is the scope of the particular crime Congress has outlined in 18 U.S.C. subsection 1512c2? In the United States of America, men are not subjected to criminal punishment because their conduct offends our patriotic emotions or thwarts a general purpose sought to be effected by specific commands which they have not disobeyed, nor are they to be held guilty of offenses which the statutes have omitted, though by inadvertence to define and condemn. Our commitment to equal justice and the rule of law requires the courts to faithfully apply criminal laws as written, even in periods of national crisis, and even when the conduct alleged is indisputably abhorrent. Notwithstanding the shocking circumstances involved in this case or the government's determination that they warrant prosecution, today this court's task is to determine what conduct is proscribed by the criminal statute that has been invoked as the basis for the obstruction charge at issue here. I join in the court's opinion because I agree with the majority that 1512c2 does not reach all forms of obstructive conduct and is instead limited by the preceding list of criminal violations in 1512c1. I write separately to explain why and how that interpretation of subsection 1512c follows from the legislative purpose that this statute's text embodies. Our goal in interpreting any statute should be to give effect to the intent of Congress. There is no question that intent is generally expressed through the text of the statute. Hewing closely to Congress's will as embodied in the statute that it wrote is especially important when construing laws like this one, which implicate the possible imposition of punitive sanctions. Quoting Pugin v. Garland. Here, the majority rightly interprets the scope of Section 1512c2 by looking for guidance from the statutory examples that come before it, those listed in Section 1512c1. In my view, the examples that Congress opted to include in the text of a statute evince its intentions concerning what the rule covers and thereby help express a particular legislative purpose. The majority's football-based example is illustrative. In a football league, says the majority, a rule that players must not grab, twist, or pull a face mask, helmet, or other equipment with the intent to injure a player or otherwise attack, assault, or harm any player should not be interpreted as being directed at hurt feelings, because the listed prohibited actions all concern dangerous physical conduct that might inflict bodily harm. Trash talk is simply not of that kind. I agree. I would add that it is likewise clear from the listed prohibited acts that such a rule is also not addressing far more serious and unexpected conduct than the kinds of acts that the preceding examples describe, which can result in serious and foreseeable physical injuries during a rough and tumble football game. By contrast, if a player were to shoot or poison another player, the rule's drafters would expect the police to be called, not a referee. Thus, we conclude that the rule is best understood to be inapposite with respect to conduct at both extremes of the universe of harmful acts in which a player might conceivably engage. We recognize this intuitive fact, that there is a certain category of conduct the rule is designed to prohibit, because we recognized, albeit implicitly, that the drafters of this rule have included these particular examples for a reason. We understand that, given the preceding list of examples, this rule was adopted with a clear intent concerning its scope. So, though a broad conception of harm is literally covered by the language of the rule, we appreciate that the rule's drafters did not intend for that term to take on its most expansive meaning. Instead, the examples help illuminate what the drafters actually intended the rule to cover. From the preceding list, we can confidently discern that the drafters meant to prescribe only conduct that risks injuries with severity akin to face mask pulling, not trash talk or murder. The upshot is that when interpreting the scope of a particular statute or rule, our assessment of the words that the drafters used informs our understanding of what the rule was designed to do. Discerning the rule's purpose is critical when a court is called upon to interpret the provision. Turning to the statutory provision at issue here, the purpose of Section 1512C, reflected in its text, is clear. Subsection C1 is indisputably focused on persons who engage in a particular kind of obstructive conduct. Anyone who corruptly alters, destroys, mutilates, or conceals a record, document, or other object with the intent to impair the object's integrity or availability for use in an official proceeding. Subsection C2, in turn, is directed at criminal conduct that otherwise achieves a similar result. I therefore agree with the majority that Section 1512C2's reach is narrower than the government contends. As the majority holds, Section 1512C2 makes it a crime to impair the availability or integrity of records, documents, or objects used in an official proceeding in ways other than those specified in C1, and to impair the availability or integrity of other things used in an official proceeding, beyond the records documented or other objects enumerated in C1. This understanding of Section 1512C's text and purpose is entirely consistent with the statute's enactment history. Congress enacted Section 1512C as part of the Sarbanes Oxley Act, which was prompted by the exposure of Enron's massive accounting fraud and revelations that the company's outside auditor, Arthur Andersen, had systematically destroyed potentially incriminating documents. When introducing what later became subsection 1512C on the Senate floor, Senator Lott emphasized that its principal purpose was to target document destruction, which was, at the time, prohibited only if a subpoena had been issued for the evidence that had been destroyed or altered. This section, he explained, would allow the government to charge obstruction against individuals who acted alone, even if the tampering took place prior to the issuance of a grand jury subpoena. Similarly, the Senate report accompanying the proposed statute noted that current federal obstruction of justice statutes relating to document destruction were riddled with loopholes and burdensome proof requirements. According to the Senate report, subsection 1512C was drafted to fill these gaps. When a person destroys evidence with the intent of obstructing any type of investigation and the matter is within the jurisdiction of a federal agency, overly technical legal distinctions should neither hinder nor prevent prosecution and punishment. Conversely, there is no indication whatsoever that Congress intended to create a sweeping all-purpose obstruction statute. As the majority notes, federal obstruction law consists of numerous provisions that target specific criminal acts and settings. Outside of the government's proposed interpretation of Section 1512C, Congress has never enacted a one-size-fits-all solution to obstruction of justice. Meanwhile, many states have done just that. Given that Congress has never before passed a similarly broad obstruction law when others have long existed, it is highly unlikely that Congress intended for subsection C2 to establish a first of its kind general federal obstruction crime. Nothing in the enactment history of subsection 1512C suggests that Congress believed that it was creating an all-encompassing statute that would obviate the need for any other obstruction prohibitions. This conclusion is further reinforced by the fact that, unlike subsection 1512C2, nearly all of the broad, all-purpose obstruction statutes that various states have enacted are classified as misdemeanors. As a result, these types of obstruction crimes are generally punishable by up to a year of incarceration. That is so for a reason. As the Model Penal Code's drafters explained, the existence of a residual misdemeanor offense allows for the appropriately narrow definition of the serious forms of obstruction carrying felony penalties. A broad residual offense provides a hedge against the ingenuity of offenders, since not all forms of obstruction can be anticipated and precisely proscribed in specific offenses. But at the same time, that kind of broad criminal statute must incorporate certain limitations lest it nullify policy decisions expressed elsewhere. In other words, these broad misdemeanor obstruction statutes are amalgams of generality and constraint. The government's interpretation of Section 1512C2, by contrast, exhibits all the generality of these catch-all misdemeanor obstruction provisions while displaying none of their restraint. Section 1512C2 is a felony, and it imposes a 20-year maximum sentence, one of the more severe potential punishments in Chapter 73 of the U.S. Code. That stands in contrast with Congress's specification that other serious obstructive acts warrant far shorter terms of imprisonment. For example, 3 years for harassment under subsection 1512D1, or 10 years for threatening a juror under 1503. Finally, it is worth remembering the statutory context in which Congress chose to prohibit the obstruction-related conduct we are considering today. The statute Congress wrote addresses this matter in a 13-word phrase, enumerated 2, that is located within subsection C of a much broader subsection 1512. Which itself consists of a reticulated list of nearly 24 means of committing obstruction. However we might interpret Congress's drafting choices in other contexts, we should be wary of finding that a statute addresses significant criminal conduct when none of the available indicia of congressional intent, including the prohibitions placement, suggests that Congress intended that result here. Here, it beggars belief that Congress would have inserted a breathtakingly broad, first-of-its-kind criminal obstruction statute accompanied by a substantial 20-year maximum penalty in the midst of a significantly more granular series of obstruction prohibitions, without clarifying its intent to do so, not in the text of the provision itself, nor in the surrounding statutory context, nor in any statement issued during the enactment process. In my view, the Court properly interprets Section 1512C2 in the opinion it issues today. It also rightly vacates the judgment below and remands this case for further proceedings. Joseph Fischer was charged in violating Section 1512C2 by corruptly obstructing a proceeding before Congress, specifically Congress's certification of the Electoral College vote. That official proceeding plainly used certain records, documents, or objects, including, among other things, those relating to the electoral votes themselves. And it might well be that Fischer's conduct, as alleged here, involved the impairment or the attempted impairment of the availability or integrity of things used during the January 6 proceeding in ways other than those specified in C1. If so, then Fischer's prosecution under 1512C2 can and should proceed. That issue remains available for the lower courts to determine on remand. Justice Barrett, with whom Justice Sotomayor and Justice Kagan joined dissenting. Joseph Fischer allegedly joined a mob of rioters that breached the Capitol on January 6, 2021. At the time, Congress was meeting in a joint session to certify the Electoral College results. The riot forced Congress to suspend the proceeding, delaying it for several hours. The Court does not dispute that Congress's joint session qualifies as an official proceeding, that rioters delayed the proceeding, or even that Fischer's alleged conduct, which includes trespassing and a physical confrontation with law enforcement, was part of a successful effort to forcibly halt the certification of the election results. Given these premises, the case that Fischer can be tried for obstructing, influencing, or impeding an official proceeding seems open and shut. So why does the Court hold otherwise? Because it simply cannot believe that Congress meant what it said. Section 1512C2 is a very broad provision, and admittedly, events like January 6 were not its target. Who could blame Congress for that failure of imagination? But statutes often go further than the problem that inspired them, and under the rules of statutory interpretation, we stick to the text anyway. The court, abandoning that approach, does textual backflips to find some way. Anyway, to narrow the reach of subsection C2, I respectfully dissent. The case for the government's interpretation is straightforward. It can be accomplished in 3 paragraphs as compared to the court's many, many more. Start with the verbs. To obstruct and to impede mean to hinder or retard something's passage or progress. We have previously explained that these words are broad. To influence is similarly expansive, meaning to affect the condition of or to have an effect on something. The object of these verbs is an official proceeding defined to include a proceeding before the Congress. So C2 covers all sorts of actions that affect or interfere with official proceedings. Otherwise, which introduces 18 U.S.C. subsection 1512 C2 does not narrow its scope. Otherwise means in a different manner, by other means, or in other respects. It is often used to introduce a catch-all phrase. Here, otherwise tells the reader how C1 and C2 fit together. Subsection C1 prohibits altering, destroying, mutilating, or concealing a record, document, or other object with intent to impair its integrity or availability for use in an official proceeding. In other words, C1 targets document and object spoliation. Classic means of obstruction. Subsection C2 then prohibits its obstructing, influencing, or impeding an official proceeding by means different from those specified in C1, thereby serving as a catch-all. The enumerated crimes in C1 and the unenumerated crimes in C2 are similar on one specific dimension. The particular similarity specified after the otherwise. The enumerated crimes in C1 and the unenumerated crimes in C2 are similar on one specific dimension, the particular similarity specified after the otherwise. Here, that means that each crime represents one means through which to obstruct, influence, or impede an official proceeding. Joseph Fischer allegedly participated in a riot at the Capitol that forced the delay of Congress's joint session on January 6. Blocking an official proceeding from moving forward surely qualifies as obstructing or impeding the proceeding by means other than document destruction. Fischer's alleged conduct thus falls within C2's scope. Opting for a narrow approach, the court declines to take C2 on its own terms. Instead, it borrows the evidentiary focus of C1 to hold that a defendant violates C2 only by impairing the availability or integrity for use in an official proceeding of records, documents, objects, or other things used in the proceeding. Other means of obstructing a proceeding, say by shutting it down, are out. This interpretation might sound faithful to the statute because the limit comes from a related provision rather than thin air. But snipping words from one subsection and grafting them onto another violates our normal interpretive principles. We ordinarily resist reading words or elements into a statute that do not appear on its face. And where Congress included particular language in one section of a statute but omits it in another section of the same act, we generally presume that Congress did so intentionally. The court's reasoning for departing from these rules are thin. The court begins with the Noscitur Associs and Ejusum Generis canons. The Noscitur canon counsels that words grouped in a list should be given related meaning. It is particularly useful when interpreting a word that is capable of many meanings. The Ejusum canon applies when a catch-all phrase follows an enumeration of specific, as in dogs, cats, horses, cattle, and other animals. We often interpret the catch-all phrase to embrace only objects similar in nature to those objects enumerated by the preceding specific words. These canons are valuable tools, but applying either to C2 is like using a hammer to pound in a screw. It looks like it might work, but using it botches the job. Unlike the pattern to which the Noscitur canon applies, subsection 1512C is not a list of terms that includes an ambiguous word. So the court does not do what it does when applying non citor. select between multiple accepted meanings of the words obstructs, influences, or impedes. Instead, it modifies those words by adding an adverbial phrase obstructs, influences, or impedes by impairing the availability or integrity for use in an official proceeding of records, documents, or objects. The edusum canon is an equally poor fit. Unlike the pattern to which edusum applies, it is not a general or collective term following a list of specific items to which a particular statutory command is applicable. Instead, C1 and C2 are distinct and independent prohibitions. Though they share a subject and an adverb, however corruptly, the two clauses contain different verbs that take different objects. Moreover, C1 has a separate mens rea provision that further disrupts the connection between the clauses. To my knowledge, we have never applied either of these canons to a statute resembling subsection 1512C. Rather than identify such a case, the court invents examples of a sign at the zoo or a football league rule. The zoo example, do not pet, feed, yell, or throw objects at the animals or otherwise disturb them, does not help because it mimics the typical edusum format of specific words followed by a catch-all. The list of specific verbs makes clear that the cleanup phrase, otherwise disturbed, is limited to conduct that involves direct interaction with the animals. But in the absence of a laundry list followed by a catch-all, it is hard to see why the edusum canon fits. The court's football example is only slightly better. As a refresher, a football league might adopt a rule that players must not grab, twist, or pull a face mask, helmet, or other equipment with the intent to injure a player or otherwise attack, assault, or harm any player. If a linebacker shouts insults at the quarterback and hurts his feelings, has the linebacker nonetheless followed the rule? Of course he has. The examples of prohibited actions all concern dangerous physical conduct that might inflict bodily harm. Trash talk is simply not of that kind. Put aside that it's hard to imagine anyone describing trash talk as inflicting an injury or harming a player in a football game. The league rule plainly forecloses the possibility. Consistent with the non satur canon, harm takes its meaning from its companions attack and assault. And while the court tries to track subsection 1512C structure by adding an extra intent clause, the two clauses in its example are still tightly focused on actions directed at the player. After all, who is wearing the face mask, helmet, or other equipment? Given that shared theme, it is easy to understand that the first clause's focus on physical conduct limits the only slightly more general clause. But subsection 1512C's subsections are not so closely related. C1 focuses specifically on objects in a proceeding, and C2 broadens the lens of the proceeding itself. Consider a rule that actually mirrors section 1512C. Any player who punches, chokes, or kicks an opposing player with the intent to remove him from the game or otherwise interrupts, hinders, or interferes with the game shall be suspended. While the specific verbs in the first clause involve actions directed at an opposing player, the second clause is a separate prohibition with an entirely different object. Imagine that just before the opposing team's kicker attempts a field goal, players leave the sideline and storm the field, some tackling referees in the process. Those players have surely interrupted, hindered, or interfered with the game, even though they have not physically injured any opponent. This hypothetical, not the court's, is analogous to subsection 1512C, and it supports the government's interpretation. The court next recruits help from Begay, which interprets an otherwise clause in the Armed Career Criminal Act. The ACCA defines a violent felony as a felony that is burglary, arson, or extortion, involves the use of explosives, or otherwise involves conduct that presents a serious potential risk of physical injury. Begay holds that the example crimes limit the catch-all clause to crimes that are roughly similar to the examples themselves. So too here, the court reasons the list of crimes in C1 limits the otherwise clause in C2. But subsection 1512C is structured differently than the statute in Begay. While section 1512C contains two distinct criminal prohibitions, C1 and C2, the statutory definition in Begay contained a list of examples followed immediately by a residual clause. The latter structure more readily supports interpreting the general clause in light of the specifics, much like a statute to which the edusum canon would apply. Moreover, the residual clause at issue in Begay called called out for a limiting principle, what is a serious potential risk of physical injury. The breadth itself was a cue that the interpreter should read back to find some limit. Subsection C2 otherwise clause, by contrast, stands on its own. The postscript. 7 years after Begay was decided, we held ACCA's residual clause void for vagueness, so the clause is not only distinguishable, but also a poor model for statutory interpretation. The court argues that there would have been scant reason for Congress to provide any specific examples in C1 if C2 covered all forms of obstructive conduct. Conduct like destroying and concealing records obstructs, influences, or impedes an official proceeding. So Congress could have enacted just C2 and been done with it. On the government's interpretation, the court asserts, the second prohibition swallows the first. If C1 has any function, it must be to cast light and impose limits on C2. What the court does not say is that its rewrite also eliminates the need for C1's examples. The court's interpretation assumes that Congress used a convoluted two-step approach to enact a prohibition on impairing the integrity or availability of records, documents, or other objects for use in an official proceeding. So why didn't Congress just say that? And if the court is right about what C2 means, why do we need specific examples in C1? Those acts are already covered. The problem of C2 subsuming C1 is therefore not unique to my theory. It bears emphasis, though, that the broad overlap makes sense given the statute's backstory. When the Enron scandal occurred, Congress, along with the general public, was taken aback to discover that seemingly criminal conduct was actually not a federal crime. As it then existed, subsection 1512 had a loophole. It imposed liability on those who persuaded others to destroy documents, but not on the people who themselves destroyed documents. Congress enacted subsection 1512C to close this Enron gap. Subsection C1 deals with the particular problem at hand, document destruction. Subsection C2 reflects Congress's desire to avoid future surprises. It is a catch-all for matters not specifically contemplated, known unknowns. So contrary to the court's suggestion, it would not be peculiar for C2 to cover conduct far beyond the document shredding and similar scenarios that prompted the legislation in the first place. Enron exposed more than the need to prohibit evidence spoliation. It also exposed the need to close statutory gaps. And in any event, statutes often reach beyond the principal evil that animated them. That is not grounds for narrowing them, because it is ultimately the provisions of our laws rather than the principal concerns of our legislatures by which we are governed. While the court insists that C1 limits C2, it cannot seem to settle on the common attribute in the first subsection that cabins the second. On one hand, the court says that C2 makes it a crime to impair the availability or integrity of records, documents, or objects used in official proceeding. This physical evidence limitation tracks the district court's interpretation. On the other hand, the court says that C2 prohibits impairing the availability or integrity of other things used in an official proceeding, such as witness testimony or intangible information. This broader evidence impairment theory resembles Judge Katz's interpretation. Both formulations are problematic, and not only because both are atextual. The first focuses solely on physical items, would leave C2 with almost no work to do. Subsection C1 already prohibits altering, destroying, mutilating, or concealing documents, records, or objects. This essentially covers the waterfront of acts that impair the integrity or availability of objects. True, C2 could also encompass covering up, falsifying, or making a false entry in a record or document, but it seems unlikely that Congress used the expansive language of C2 to address such narrow concerns. The somewhat amorphous other things limitation that has the benefit of giving C2 a wider berth, but it is unclear how the court landed on it. The term does not appear in C1 or in subsection 1512's surrounding to subsections, which refer specifically to records, documents, objects, and testimony. The other things formulation comes from the court, not Congress. The court's uncertainty about the relevant common attribute is a tell that Congress did not intend to define C2 by reference to C1. Indeed, had Congress intended to limit subsection 1512C2's reach, as the court asserts, it easily could have written the catch-all to say otherwise impair the integrity or availability of records, documents, objects, or other things for use in an official proceeding. It did not, and we should not pretend that it did. The court relies on statutory context to confirm that C2 is limited by the scope of C1. As the court sees it, interpreting C2 according to its plain text would render other obstruction provisions within Section 1512 and throughout Chapter 73 superfluous. The court exaggerates. Subsection C2 applies only to conduct that obstructs an official proceeding. The court highlights several provisions that cover obstruction of investigations. The circuits have held that criminal investigations do not qualify as official proceedings. Likewise, not every provision in subsection 1512 relates to an official proceeding. Instead, several target the obstruction of communications to judges and law enforcement about the commission of federal offenses. The court responds by stressing that for purposes of subsection 1512, an official proceeding need not be pending or about to be instituted, because obstruction of investigations or communications could end up obstructing the initiation of a future official proceeding. The court reasons that C2 may still swallow those other provisions. But we have previously construed federal obstruction offenses similarly to subsection 1512C to require a tighter link between the obstructive conduct and the relevant proceeding. Under the nexus requirement, the defendant's conduct must have a relationship in time, causation, or logic with the proceeding, and the defendant must act in contemplation of a particular official proceeding. The circuits have unanimously applied this requirement to subsection 1512C. This element eliminates much of the overlap that the court perceives between C2 and the provisions that do not require an official proceeding. Moreover, subsections 1512A1A and D1 prohibit preventing the mere attendance of any person in an official proceeding. Preventing attendance will not always have the effect of obstructing, influencing, or impeding the proceeding. And 1512D1 makes it a crime to intentionally harass someone and thereby dissuade her from testifying in an official proceeding. In contrast to C2, this provision, which carries a significantly lower maximum penalty, does not require a defendant to act corruptly. This is not to deny that C2, if allowed its broad, ordinary meaning, overlaps with several offenses in Chapter 73. Even so, C2 still leaves a healthy amount of work for other obstruction offenses, and besides substantial overlap, it is not uncommon in criminal statutes. The mere fact that two federal criminal statutes criminalize similar conduct says little about the scope of either. That is especially true here, because Congress enacted C2 after it had already enacted other subsections of Section 1512, as well as obstruction offenses like subsections 1503 and 1505, the redundancy argument would have more force if C2 rendered superfluous an entire provision passed in proximity as part of the same act. As it stands, the canon against surplusage does not provide any reason to artificially narrow C2's scope. In any event, the court's formulation does not begin to cure the statutory overlap. Killing a person with the intent to prevent the production of a record in an official proceeding constitutes conduct that impairs the availability of a record for an official proceeding. Using physical force against a person to influence testimony in an official proceeding counts as impairing the integrity of other things used in an official proceeding, and impairing the availability or integrity of documents for use in an official proceeding will often influence, obstruct, or impede the due administration of justice. Examples abound. In fact, the broader statutory context works against the court's interpretation. Congress did not select the verbs obstruct, influence, and impede at random. Those words were already in subsection 1503, which prohibits corruptly or by threats of or force or by any threatening letter or communication influencing, obstructing, or impeding the due administration of justice. We have described this omnibus clause as a catch-all because it follows several specific proscriptions against coercive behavior towards jurors and court officers. Courts have routinely declined to read the Omnibus Clause as limited to acts similar in manner to those prescribed by the statute's specific language. And Justice Scalia agreed that ejusdem generis did not apply to limit the Omnibus Clause, one of the several distinct and independent prohibitions contained in subsection 1503 that share only the word whoever, which begin the statute, and the penalty provision which ends it. Section 1512C follows the very same pattern. The court concludes that an appeal to consequences construing C2 broadly would expose activists and lobbyists alike to decades in prison. This fear is overstated. To begin with, the court ignores that C2 requires proof that a defendant acted corruptly. The meaning of this term is unsettled, but all of its possible definitions limit the scope of liability. On one proposed interpretation, a defendant acts corruptly by using unlawful means or acting with an unlawful purpose, or both. On another, a defendant acts corruptly if he acts with an intent to procure an unlawful benefit either for himself or for some other person. Under either, the corruptly element should screen out innocent activists and lobbyists who engage in lawful activity, and if not, those defendants can bring as-applied First Amendment challenges. The court also emphasizes C2's 20-year maximum penalty, but it simultaneously glosses over the absence of any prescribed minimum. Congress presumably enacts laws with high maximums and no minimums when it thinks the prohibited conduct may run the gamut from major to minor. Indeed, given the breadth of its terms, C2 naturally encompasses actions that range in severity. Congress presumably trusted district courts to impose sentences commensurate with the defendant's particular conduct. There is no getting around it. Section 1512C2 is an expansive statute, yet Congress, not this court, weighs the pros and cons of whether a statute should sweep broadly or narrowly. Once Congress has set the outer bounds of liability, the executive branch has the discretion to select particular cases to prosecute within those boundaries. By atextually narrowing Section 1512C2, the court has failed to respect the prerogatives of the political branches. I respectfully dissent. Well, that was a good read. And as always, if there's any case you'd like me to read, just drop in the comments and I would be happy to take a look. Thank you.